We have a decided lack of authors with more work to do. I know. All right. I guess I will take up the barbell. I will pass the chairmanship to Mr. Wagner.
All right, we are on item 9, AB 2878, a judiciary bill dealing with the State Bar. Mr. Chairman, when you're ready, you may proceed.
Thank you, Mr. Chair and members. This is the annual State Bar dues bill that comes before us. It is generated out of the Senate one year, the Assembly the next. This is our year to do this. And it keeps the bar fees of $390 the same as they have been for the last 3 years. This is also the legislature's opportunity to fulfill its oversight role of the State Bar, and that's what this bill does. Now, we have several items that we are still waiting for. The audit that was called for in the last year's bar bill. We are also waiting for the governance task force for the bar to complete its work, as well as the spending plan and the workforce plan. So as this bill moves forward, we will be seeing some amendments in this House and also as it moves to the Senate.
May I interrupt you for a moment? It's my understanding Ms. Gonzalez wanted to be here for this bill, so if we could have the sergeants contact her office and let her know she's on her way. Very good. Make sure she had that opportunity. Thank you.
Thank you. Thank you. So what it doesn't do, what this bill does not do yet, is address those issues that will be coming to us through the audit, through the governance task force, spending plan, workforce plan, and others. Members of this committee have raised issues with the bar bill and with the organization of the bar. I think clearly what has been in the paper and what has been talked about quite a bit with the bar. The bar is in the middle of a lot of reform. I think it is incumbent on the legislature to be a significant part of that reform and ensure that the bar meets its obligations, public protection, of managing the lawyers in the state of California. I've been meeting with the chair of the Senate Judiciary Committee as well as the Chief Justice and executives from the bar in order to facilitate that conversation and make sure that as the bar bill moves forward, we have vetted all of the issues we need to vet, that we put the amendments in and do our job of governance and oversight with respect to the State Bar. We do have some witnesses in support. Elizabeth Parker is with me, who is the State Bar Executive Director, and I know that there are lots of perspectives on this. I was hoping by the time we presented this we would have a full committee, because I know committee members that I've been in conversation with have questions and concerns about the State Bar moving forward. This is our opportunity, and with that I'll move to our witnesses. And I would also like to invite committee members to make sure that they stay engaged with this conversation, because as the bill moves forward, it will be amended. My promise to the Chief Justice is to keep her well informed. Obviously, we're working very closely with the Senate Judiciary Committee on this, and I want to make sure that all of the members of Assembly Judiciary Committee are as well informed as possible as this bar moves, because we are the spokespeople for this bill with respect to our colleagues, and when it goes through the appropriations process to the Assembly floor over to the Senate, we're going to be the ones held accountable to what's in the bill. So with that, I ask for your aye vote at this point and look for our witnesses.
Thank
and
you.
Ms. Gonzalez.
First witness in support. Welcome.
Yes. Well, thank you very much, Chairman Stone and members of the committee. Good morning. I am Elizabeth Parker, and I have with me the two other members of our new leadership team, Leah Wilson, and behind me, General Counsel Vanessa Holton. I want to begin by complimenting the staff who prepared a really wonderful analysis, and I think probably it is so thorough that I don't need to say a great deal more, but a couple of personal comments, if I might. The new team, pardon me, I seem to have caught whatever it is that's going around this room. The new team,
it's an old building.
Okay, is now just entering its 7th month, and so we are brand new and learning and working hard to accomplish, frankly, a very important set of tasks that you set upon us last year and that are very valuable, and I'm sure you're as familiar with them, but I'll just simply name them quickly: workforce planning, classification and compensation review, zero-based budgeting. Importantly, we've already managed to reduce our budget this year by 6.2%. So we do hear you. And we're also addressing a long overdue need for a new case management system, as well as redesigning our website. So your oversight process and that of the Supreme Court, we think, is really working effectively. I should add, however, that as a brand new team, we do have a great deal of learning to do. And I might just explain as to how we arrived, all three of us, simultaneously in September, October. Our Board of Trustees, as you may have observed, is not always unanimous on all points. But on one point, I think they did agree, and that was that the bar needed a new direction. It needed an approach that would be transparent, accountable, and would achieve excellence through establishing the trust we need with your committee and the Supreme Court. And to that end, they chose to reach out to those who, while they'd had management experience, had never had any involvement with the bar in a management capacity. And I think what they were signaling for you is change, transformative change, and indeed that is what we are about. We have committed ourselves to own, albeit we may not have originated many of the problems you've described. So we do have legacy problems. We're aware of them. We didn't make them, but it's our job now to correct them, and that is our pledge to you. We have another pledge which I want personally to underscore, as I have to many of you individually, and that is, as a new team, rushing fast, we may make mistakes. Indeed, I think several of you will be able in questioning to point to some of those mistakes. But when we do, we also pledge that we will come forward and be honest and complete in correcting those mistakes. And I think you really would have to agree that that is what you would expect of any servant of the public, particularly one engaged in public protection. Now, I know my time is limited, and so let me end with just a thought as to the context in which many changes are being suggested this year. These are, what shall we say, interesting times to be the executive director of the State Bar. We have a vitally important, I believe, public protection mission, and indeed it is why I chose to leave retirement and join the bar as its executive director. But when we think of that public protection mission, I would encourage that we think not just about responding to those who violate rules, but also thinking proactively as to the legal system we want. You mentioned, importantly, the support that the bar historically has given for legal services. But if you consider that the problem is much broader than that, with 85% of our population not represented currently, and indeed many of our diverse population not feeling inclusion, I think you see that we have a proactive public protection mission that has to combine with our responsive public protection mission. And so with that, I'll say that we look forward to working with this committee and with the Supreme Court in achieving an even better bar, state bar organization.
Thank you, Ms. Parker. Additional witnesses in support.
All right, so this is a little unorthodox.
All right, this is a little unorthodox.
We
Nevertheless,
find no other way to do it.
the chairman and I have discussed it, and out of deference and consideration to a colleague, you may have a couple of minutes and
Thank you.
proceed.
And thank you, Chair, for allowing me, and Vice Chair, to allow me to join you today at the committee hearing for AB 2878. I'm a proud member of the California State Bar, and every year I pay my dues, happily. But as an attorney, and more importantly, as a legislator, I assume the bar is doing its job. Pursuant to Business and Professions Code Section 6001.1, protection of the public shall be the highest priority of the State Bar and the Board of Trustees in exercising their licensing, regulatory, and disciplinary functions. Whenever the protection of public is inconsistent with other interests sought to be promoted, the protection of the public should be paramount. It seems, however, that protecting the public has not been the highest priority of the bar. In particular, the bar has completely neglected to address nearly 300 complaints dealing with the unauthorized practice of law. According to an article published in the Daily Journal, these cases were simply placed in a drawer that said "read drawer." Furthermore, the annual discipline report to the legislature lacked information data regarding the unauthorized practice of law claims. This is especially disconcerting given the bipartisan passage of two bills through the legislature and signed by the governor, AB 1159, which was in fact sponsored by the bar, and AB 60, directing the State Bar to help protect immigrants from the unauthorized practice of law, as well as fraudulent attorneys. Under the Chief Trial Counsel's leadership, we've seen inaction and buildup of the UPL cases. The inaction of investigating UPL cases, of course, deter new claims from being made by people since they don't expect to see results. We've had multiple hearings in this building about the need to allow the bar, or actually ask the bar to handle these, because so often immigrants have no place else to go. They often will not alert a DA or a city attorney for fear of the consequences of doing so. So the bar was, in fact, they stated and continue to state that they were the appropriate place for immigrants in particular who were being defrauded by notarios and others who had nowhere else to go to the bar. I think it is more than disconcerting that all of these complaints, as far as we know, were placed in a drawer. And as much as we're talking about transparency and a new governance, we were never told about this. In fact, it was a whistleblower who alerted the Daily Journal to this problem. I think it's a responsibility of the bar and our responsibility as a legislature to ask these questions, and I know of no other time to do it except to ask when the bar comes forward and asks for their dues bill. Again, I pay dues. I appreciate that. I know that this is an important bill to get through, but I also think it's an important piece of our role to ask and question what the plan is in order that we actually see the bar protecting all Californians, especially those directed by this legislature to protect the most. Thank you.
All right. I am going to ask Ms. Parker or whomever to respond when the time comes. We're kind of a little out of order here, and at this point, let me ask: are there any other witnesses in support? All right. Witnesses in opposition. Witnesses sort of in the middle. Yeah, I mean, you're welcome, Mr. Majors. Welcome, former member. Welcome back.
Thank you, Mr. Chair and members. My name is Dennis Mangers, and as many of you know, I had the great honor to serve in the State Assembly in the 70s while most of you were children. At the end of my professional career, the Senate asked me if I would accept an appointment as a public, non-attorney member of the State Bar's then Board of Governors. And I agreed, and I'm now in my second term. When I entered my first term, under the recommendation by the Senate that I analyze the governance of the State Bar, I was assigned to the Task Force on Governance in the Public Interest, during which I came to the conclusion that the major problem at the bar, and the only real way to solve the litany of issues that you see in your very fine analysis, was ultimately to separate the regulatory and trade association functions that are currently unified in the California State Bar. At the time, the legislature did not have the stomach, it seemed at the time, to take that issue on, and I was advised to make other recommendations, which I did, two-thirds of which ended up in a bill called SB 163, which reduced the number of members of the Board of Governors, and it reduced the number of electeds, if you can still believe that attorneys elect one another to the regulatory body, but it was tinkering around the edges. So, Mr. Chair, now I'm a member of the yet second task force on the governance in the public interest, and I call your attention to page 14 of your very detailed analysis, because the crux of what I'm recommending to you today is that I support the fee bill, but only if ultimately amended, to finally deal with the major critical issue before us, and that is this body has become distracted from its regulatory responsibilities because of its fascination with its trade association functions. And that has to end. So you've read the analysis. I've had the opportunity to talk to most of you, so I will not take a lot more time except to say what my colleagues and I, who are taking this position, are recommending is that Mr. Stone, the very capable chair of this committee, and Senator Hannah Beth Jackson, his Senate counterpart, collaborate with the Chief Justice. And together, they resolve that what this legislature will do on the Senate side is adopt amendments that will direct the bar to come back to this honorable body within a year with a plan for how it can deunify itself into two separate bodies, as most of the other major states in California have done. And a year hence, the legislature will then enact enabling legislation that by January of 2019 will find the California State Bar finally decoupled with regard to its trade association and regulatory functions. If the judges can do it, as they did years ago, if the doctors can do it, as they did years, as the doctors asked the legislature to help them do, then surely there is no justification for attorneys being the only remaining profession in California that is still allowed to regulate itself with self-elected lawyers who often believe that they are representing constituencies of lawyers in their respective districts more so than they are the public protection. So I ask you, as believe me, a totally objective, what is in it for me, a totally objective, non-attorney public member sent by the legislature to make this analysis, it's taken me nearly 5.5 years to come to this irrefutable conclusion that this is what we must do. While it won't happen, I'm told, in today's hearing, I believe that this chair and Senator Jackson, with the chief, could come to an understanding that would ultimately lead to legislation in this regard. So I hope this committee will send strong messages to your Senate counterparts that you have the feeling that the time has come, the winds of change are upon us, and that it's time to separate these two functions at last. Thank you, Mr. Chair.
Thank you. Additional witnesses in opposition or sort of opposition? Go ahead.
Thank you. My name is Heather Rosing. I am an attorney from San Diego. I just finished a 4-year term on the Board of Trustees. I'm attending today with Mr. Mangers. I was a 2-time officer of the State Bar of California, and I am in support of substantial changes to the governance structure. Mr. Mangers articulated our position, which is that the chair work with the Senate side and the Chief Justice to adopt the amendments we propose, essentially to deunify or decouple the bar. I just wanted to give you a little bit of our reasoning, and I will be brief. The Board of Directors of the State Bar of California is a well-intentioned and very good group of people. We have an immensely talented staff that I cannot speak highly enough of. But this is an immensely complicated organization. With so many moving parts, it took me a year, my whole first year on the board, to even understand it. And I can tell you with great certainty, because of all of the different moving parts in the organization, there is a distinct lack of focus on the core regulatory function, which is discipline. And that is, again, from my 4 years on the board, and Mr. Mangers and I have been very involved in the discipline system in particular. I can tell you what happens when there is a singular focus on a regulatory function, because we do have that in one component of the State Bar. The State Bar has a committee called the Committee of Bar Examiners, and it's different than the Board of Trustees, and all they do, they have no trade association functions, no professional association functions. All they do is regulate admissions. An amazing group of people. And you know, the best functioning part of the State Bar of California, by far, in my opinion, is admissions. So we've shown what we can do when we have a focus on the regulatory function. I can tell you, too, that the organization, in my opinion, has had some challenges with being, as Mr. Mangers has utilized in his phraseology, spasmodic. For example, we have been asked to do strategic planning by way of SB 163 in 2012. A strategic plan was proposed by the staff. It was entirely staff-driven. The board gave it almost no focus for many years. Then last year, we went through a very intense strategic planning process, and then that strategic planning process was completely abandoned subsequently. There has been little resemblance to anything that could be called strategic planning in the State Bar. I truly believe that if we were to take the regulatory functions pursuant to our proposal and have that board, that body, concentrate on the core functions of discipline, admissions, and the other regulatory aspects, and we allow the rest of it to go into a trade association or professional association environment, it would be good for everyone. It would serve the public. We would be able to best protect the public with our focus on the regulatory function. And as somebody who loves the profession of law and loves lawyers, I can tell you that the profession of law would be well served by a trade association that would not be burdened by the many constraints of a regulatory association. So we thank you very much for the time, and I appreciate the opportunity.
Thank you. We've had one witness in support, 3 against. So at this point, Mr. Howard, name, organization, and position, and we will move on.
I think that they're in support if amended.
Supportive amendment.
Right.
It sounded like an awful lot of opposition to me.
Thank you, Mr. Chairman.
Name, entity, and position, and we will move on. Thank you.
My name is Ed Howard, Center for Public Interest Law at the University of San Diego, in strong opposition to this bill.
Thank you.
Thank
Are
you.
there additional witnesses in opposition? Okay, I think we had a late arriving support.
Good morning. Thank you. I was trying to get in the door, so my apologies. You went so quickly on the support. My name is Gina Lara. I'm a practicing attorney in estate planning, trust, and probate law in Sacramento. I've been practicing 20 years. I'm also the vice chair of the Trust and Estates Executive Committee of the State Bar. I've been serving on that committee for over 6 years. I have another 4 years to go in my term. And I wanted to just speak on behalf of the Trust and Estates Executive Committee relative to this issue of deunification. That is, there are executive committees of the State Bar in various practice areas. For example, trust and estates, business law, labor law, family law. And these executive committees consist of dedicated, hardworking attorneys whose sole focus is to advance the state of the law on behalf of the public. To refer to us as trade associations associated with the bar, in my opinion, and I think the opinion of the members of TexCom, is grossly unfair and grossly understates the service that we provide to the public. We spend hours. I was the chair of the legislation committee that was part of TexCom. I chaired that. I served on it the entire time I've been on TexCom. We review, pardon me for rushing, every piece of legislation that is proposed through our committee. Every piece of legislation that is proposed. It took me over 2 hours each day to review your hard work that you put out each year. During the legislative season, to make sure that there was not a proposal that was in our domain or touched our domain that would not be to the advantage of the public. So to refer to the executive committees of the State Bar as trade associations, those are for lawyers serving lawyers. The ABA, in my opinion, American Bar Association, is for a lawyer serving lawyers. We don't want to become the ABA. We want to be part of the State Bar. We want to advance the public interests of the State Bar through our practice area. We consider ourselves subject matter experts. We are not trying to feather our nests. We're not trying to have martinis after our meetings on Saturdays. You know, when I have to get up at 4 o'clock in the morning and fly to L.A., and then, we're not trying to get the bar to pay for those things. What we're trying to do is advance the public interest. So we strongly, and I guess I should get to my point, oppose any form of deunification. Now, I read with interest the analysis of this bill, and I feel like I've stepped into a firestorm. And I'm not saying the State Bar doesn't have problems. When I saw the loans and the lack of discipline for the unauthorized practice of law, I was just as appalled as the people who testified in opposition. But to punish the sections for this when we try so hard to advance the public interest, I think is really inappropriate. And I came out today on behalf of TexCom to let you know that we are opposed to it. I understand, and I'll conclude now, that there's about, and I wish I was more prepared, 16 sections in the executive committee sections in the State Bar. Only one of them wants to deunify. The rest of us want to stay with the State Bar because we're proud to be part of the State Bar. When I say I'm part of TexCom, when I'm the vice chair, which is Trust and Estates Executive Committee of the State Bar, I say it with pride because I think we're doing good work. And so I would ask you to, I feel like it's not properly before you anyway, the deunification, because it's not in the bill, but when it's amended, I hope you'll at least remember my impassioned and slightly neurotic comments and, think about the deunification and what it will do to our group. We will no longer be advocating for the public. We'll be advocating for lawyers who practice estate planning, which I think is a huge disservice to the public.
Thank you.
So thank you.
Thank you very much. Additional witnesses, and I think we're just to name, affiliation, and position, please.
Vanessa Kirker-Wright. I'm the chair of the family law section of the bar. We join with TexCom's comments and hope that you'll continue to have us be as stakeholders as this bill moves along with regard to deunification. Thank you.
Thank you very much.
Donna Parkinson, former chair of the business law section and secretary to the California Lawyers Guild, a newly formed statewide organization. It's inaccurate to say that 15 out of 16 of the sections are against the disunification of the bar. There are about 5 or 6 that have taken a position, but for the most part, they're either not taking a position or business law section has taken a position in favor of disunification. We support the Mangers-Rossing restructure proposal.
Very good. Thank you very much. Additional witnesses, I guess, on any side of the subject. All right, let's bring it back to the committee. And I saw Mr. Mainshine first and then Mr. Chu.
Thank you very much, Mr. Chairman. I wasn't planning on speaking, but my friend and colleague, Ms. Gonzalez, has kind of inspired me to say a couple things. You know, I also pay dues to the State Bar, and read with interest the 2015 State Auditor's Report, which was scathing. I mean, it was really pretty disturbing to read. I do appreciate that some steps have been made in the last year on this, but I think a lot more needs to be done. Ms. Gonzalez raised some pertinent points about this, and I think there's a number of others that were identified in that report that still need to be addressed. It's good that steps are being taken, but there's a lot more to do. I would, one of the comments I think that I heard was, this is some of the proposals are some sort of punishment. I guess I would, at least for me, what I'm interested in is having an agency that functions correctly. It's not, I don't think there's punishment on the correct functioning of an organization, not wasting money, serving the public, disciplining lawyers that don't practice law correctly. So I don't think it's about that in any way. I'm very interested. I haven't had a chance to evaluate this deunification proposal. I am interested in it because I think it raises some really good points. And so I want to learn more about that, and that might be something that I would be willing to support in the future. I'm glad we're not talking about a dues increase this year. So I think you are showing some awareness on that topic, so that's appreciated as well. And I'd like to hear more as we move forward in the next year. Do you have plans? Let me ask you this. Do you have plans on this deunification? What is the status of this proposal?
Well, this is part of our delayed 2014 Governance Task Force, Public Interest Governance in the Public Interest Task Force. Now, why it wasn't done in 2014, I cannot tell you, but we're busily doing it now. We framed the questions broadly because we wanted to create a big tent so that all questions could be thoughtfully looked at. We're rushing fast and hoping to have a report to the board for its consideration in July, and then that would come to the Supreme Court in this body and, of course, your counterpart in the Senate soon thereafter. I think the conversations by everyone's agreement have been robust, diverse as to viewpoint. If I might just take a moment and tell you what my personal perspective is. When I arrived, one of my first conversations was with Heather Rossing, and I said, do you think we should be talking about splitting this bar apart? It looks kind of complicated to me. In fact, I did a little diagram here so I could understand it. I thought if I were in a corporation, I'd say, let's just focus on our principal form of business and shed the rest. But from that position, I've come to realize, as I gather you have, that it's more complex than I earlier understood. And when I referenced some of the proactive things we need to do, if you look at the various functional areas, one question that arises is, where do you draw the line? So certainly some of the things we do to protect the public are responsive to bad actions, but others, which you've mandated as a legislature, look forward. So a number of these things, and of course the sections are complex as well. I think at the end of the day, the one thing I will say with some conviction, and I'm choosing an unfortunate metaphor, but if you had a sick patient, you'd wait until the patient was healthy before operating. And I think our patient's still a little bit sick. We hope we can cure it. We hope we can take advantage of all of the good work the auditors and this committee have done, and that when we come back in about a year, we will have a robust, well-functioning organization, at which point it might be wise to think about what is the best way going forward. I'd add, too, that as you think about this, and frankly, my 7 months has not been enough to really grasp this profoundly, it is interesting to look at other states in the United States to see how they do their business, but also to look beyond our borders. Ironically, California is so large that it's almost in a class by itself, and so you almost have to look to other nations to see what kind of structures might or might not work. We're very much, I think, at the beginning of this. It is an important thing to be looking at. I think what we will be able to deliver to our board and to you will be questions. They may not all be thoroughly reviewed and considered. I doubt we'll have firm recommendations in such a short space of time. And so to that end, not wanting to make light of the important administrative and management work we have to do, I think our concern is that we get through that first order of business and then move towards what's an important second order. Should we or should we not continue with the current structure?
Well, I guess I might I think I agree with some of your comments. I would respectfully disagree that you're rushing through this. This is a 2014 report, right, that we're talking about.
That's true.
So it's not 2014
No,
anymore.
but it was not begun for reasons I don't know until I arrived in December.
I understand that. We're still talking about receiving something in
Sure,
2016.
you are.
I think that would be a mischaracterization. It would mischaracterize it to say that's rushing it. So we're now into 2016. Hopefully we'll get it in July. Obviously we'll wait and see what it is. You're right. California has way more attorneys than any other state, and looking to Connecticut or some of these other states is not going to be helpful. I'm not entirely sure what looking to other countries will do, but I'll reserve judgment on that. What I think is important is this is an organization that, Ms. Gonzalez pointed out, kind of a one niche area, but there's a whole lot of other areas where this organization has not performed well. And so I'm looking forward to seeing this. I think this deunification topic should be taken very seriously by this committee and this body. I'm looking forward to getting that report and evaluating it, and then moving on, hopefully to to a little bit brighter future for the profession from there. So,
and I was in error in not acknowledging Ms. Gonzalez's concern. She's absolutely right. There's no defense to not having addressed these matters.
Exactly. And again, I agree with her. I think she is right on that, and I think I think that's not the only area too. So if it was just one area, we could kind of nail that down. But even how that was a long period of time for that to go on without being identified. I'm glad she brought it up today, but I think it's just kind of one small area amongst many others. And so, in any event, I will look forward to.
And you will have more information shortly, as you know, with these various reports, as well as this state auditor report. So you'll have more information to inform you.
Exactly.
But I think these audit reports have been helpful. They've pointed where we do need to focus attention, and we are.
Good. Thank you. Mr. Chu.
Thank you, Mr. Chair. First of all, I want to thank everyone who's been thinking hard about this, as I have. Last year, when we sat in this committee considering last year's bar due renewal bill, I said that I had been very dissatisfied as my experience of a member of the state bar for almost 2 decades, but I was willing to give the bar time to turn the ship around. I might disagree a little bit with the analogy. I'm convinced this year that the state bar is the Titanic. And if we don't turn it around, we will only have ourselves to blame. Let me say a few things to qualify that. First, I've had a number of meetings with the new bar leadership, and I think that you are very well-meaning, and you are bringing very different and important competencies to the leadership that is much needed. But I'm of the perspective that the organization is far too gone at this point. And let me just briefly summarize, because I think we've only touched upon some of the issues that I've been focused on. Let's talk about what we have learned over the past year. First, we got an audit from the state auditor who highlighted discipline issues, the fact that we not only have had an excessive backlog, but to reduce the backlog, there are attorneys that probably should have been disbarred who receive light punishments and are still practicing law. And as you know, just a few months ago, There have been news stories of additional state bar disciplinary failures, the Drexel Bradshaw case in San Francisco, where we have many individuals in my city who've been victimized because of the failure of the state bar to place protection of the public as its highest priority. Second, let's talk about buildings. That same audit pointed out that this bar association spent $77 million on the purchase of a building in LA that this legislature had only approved $10 million for, rather than investing in your attorney discipline system. That was from an audit in June, and then we discover more recently that the same thing happened in San Francisco. And while I don't mind when money is being spent in San Francisco on real estate, after this audit, somehow the state bar decided, without input or approval from the legislature, to take a $10 million loan on a San Francisco building in the most expensive real estate market in the state. Let's continue what I refer to as Travelgate. We've learned from subsequent public records of all the travel expenses, I suppose, to learn about how bars in other countries are being run, to places critical to the functioning of the California bar in El Salvador, Mexico, Guatemala, Nicaragua, Peru, and Mongolia. And I do think, and I appreciate that that you have chosen to end the expense counts on this, but again, this is only something that we've learned recently, within the past year. And you juxtapose executives traveling to El Salvador and Mexico while we're hearing about hundreds of complaints for the unlawful practice of law sitting in drawers at the state bar with immigrants who've been victimized by so-called notario fraud artists. And as someone who, in a past life, worked in a civil rights organization to go after these and have not been able to see any conclusion as a state in our prosecution of these individuals, this is very troubling as well. So you add to that last year's Supreme Court decision that holds that the state can only invoke immunity to an antitrust action if the board is actively supervised by state officials, which we're not doing in California. And so, we know that as long as the board of trustees is run by the very attorneys it's supposed to regulate, our state could be liable for board actions. I summarize this because I want to explain why my perspective has come to where it is today. So let me just add two other things. It's been pointed out that in the wake of Prop 209, with a prohibition on affirmative action, the bar's ability to advocate for diversity in the profession and access to justice has been significantly hampered. And as the former president of the largest Asian American bar association in the country, this is something that we have just not seen leadership on from the state bar. As a former public interest attorney, I've heard from hundreds of public interest colleagues who have pointed to the failure of this bar to find funding for legal services to fund the so-called justice gap. So I lay all this out. We've had conversations about it. We could have longer conversations about it. But let me just ask one question in this way. And Mr. Menger referred to those of us who were babies when he was first working on this issue. In 1995, when I graduated from law school 20 years ago, there was a commission that issued a report about the bar and said that the main issues were who should have authority over the legal profession, should California continue to have a unified bar, what changes are needed. 1997, then Governor Pete Wilson said that the bar has become lost, its ultimate message obscured. It is part publisher, part real estate investor, part travel agent, part social critic, commingling its responsibilities and revenues in a way that creates an almost constant appearance of impropriety. I think this begs this suggestion that those who fail to learn from history are doomed to repeat it. We know it has been said by several of your trustees who've documented the long history of cyclical crisis, reform, neglect, and renewed crisis, that every director, nearly every director over the past few decades, has been replaced by a new leader, charged to be a new sheriff, a show of effort at change is made, attention of the press and bar turn elsewhere, the bar slides back into mismanagement, failure to protect Californians, and general dysfunction. Do you really feel that you can turn this around?